Welcome back to Between Two FARS. I'm Warnke Miller here once again with Michael Mark and Robert Tepfer, talking our way through ASBCA litigation just for you. We have kind of landed at a part where we begin to think about your preliminary motions, the motions to dismiss that might close out your case or at least knock some of those claims off the docket. One of the most important motions to dismiss to consider deals with Accordant Satisfaction or Release Waiver. So we're going to dedicate today's episode to that very topic. Bob, Michael, what can you tell us about a motion to dismiss based on Accordant Satisfaction?
Well, first, you've got to have an Accordant Satisfaction. What is an Accordant Satisfaction? It is where the parties agree and understand that based on all of the facts that have been laid out, that the parties agree that this is a reasonable settlement and it's fair to each side. And essentially, an Accordant Satisfaction waives everybody's rights to file further claims based on this particular case. And the FAR actually has some language in FAR Party 42.204C2 that's entitled Contractor Statement of Release. And it has a clause, and it's up there right now, that that should be inserted, or something like that should be inserted into every contract modification you do. I know when I'm reviewing contracts, I always look for release language. I don't insist that it has to be what's in the FAR. This is not a FAR clause. This is in Part 42, not in Part 52. But you want to have release language in there because you want to have something in there that the parties understand all of the facts surrounding whatever this mod is about, and they agree this is a fair settlement, and they're not going to fight about it in the future. If I don't see release language in, that is a comment that I make that goes to the legal sufficiency of that document.
One of the things that, in my opinion, you have to be very clear on is Accordant Satisfaction has a prerequisite that there be a bona fide dispute, and that dispute is being settled. And the issue that you're going to end up having a contest over is the breadth of the dispute and whether or not the matter being settled was within the parameters of that dispute. One of the biggest ways to get around these things and the biggest headaches in litigation is to claim that the individual signing the document either did not dispute that aspect at that time, so it's not covered, or that we're unaware of material facts at the time that they signed the release. It's that knowledge that they effectively had a meeting of the minds of that's key. It's the meeting of the minds, and presumptively you have to know all the facts, or at least the material facts, to have that meeting of the minds and have the release take place.
Yeah, and that obviously Accordant Satisfaction and Release Waiver of Claims is a big subject of litigation. I don't know, there are probably thousands of decisions at the boards on this kind of subject. And the boards are pretty particular about that. They will go into it to make sure that the parties actually understood all of the facts that related to that claim or REA or whatever it was. And I think this is my view is there seems to be an inclination that says, you know, if I'm going to err on the side of saying that they didn't have all of the facts. So you've got to be careful. You need to document. And again, it goes back, we've discussed the Rule 4 file. That's supposed to show that the parties understood what was going on. And so you want to make sure that you've captured that at the time that whatever this mod was being negotiated actually captured all of that information, and that the parties did understand that.
And that type of extrinsic evidence would want to be in the Rule 4 file at the inception. Yes. If you have a dialogue going on about things of that nature and the individual is claiming it's not covered, I was unaware, it certainly is fun to have a email where that's the essence of the discussion, or at least it shows that they understood the facts.
And these motions to dismiss, they're made pretty early in the case, right? Before, oftentimes, if you can do it before you get discovery underway, if you've already got the documents in your own file, you can shortcut a lot of the expensive, time-consuming litigation efforts by filing one of these motions to dismiss based on accordant satisfaction or release and waiver, depending on whether or not you settled a claim directly, or if sometimes look to your contract modifications. All of your modifications should have a release and waiver, like Michael was saying. And if you covered the subject of the dispute when issuing that contract modification, that can also be brought to the table as a release and waiver on the particular claim being faced in front of the ASBCA. Any other pointers or tips you'd give to attorneys that are facing their first litigation in front of the ASBCA on this issue?
Well, one of the things that I think is critical is that a lot of transactional attorneys might omit a necessary release and waiver, and they might even think, well, we're going to pay all costs. The fact of the matter is that notwithstanding the fact that we may pay all costs, particularly in a formula contract with a cost-sharing arrangement, it could impact the amount of fee that they receive. So regardless, even on a routine modification, it needs to be cut off, and that needs to essentially state, these are the facts, you've agreed to it, and this is the release. Okay?
Excellent. Thank you, gentlemen, so much for your insight on this very important topic. We'll keep going, working our way through ASBCA litigation in the next episode of Between Two FARS. Join us again next time.